Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday. That's why I said Wednesday court. See, I know what day it is. We got some Michael Fish up today. And I don't know, we'll finish with another judge. Here we go.
Good morning, jail. Do you have us okay?
Yes, Your Honor.
Good morning, everyone. I'm Judge Mike Fish. Welcome to Porter Superior Court 1. This is our Friday morning level 6 felony call. If you're in court for some reason other than a level 6 felony, you're in the wrong place, and you should talk to security about how they can redirect you. State, let's get started with Stevie Seymour. Can you please set our record?
Yes, Your Honor. Thank you. This is State of Indiana versus Stevie Seymour. Cause number is 64D012409F69182. This defendant appears in court in person by video conferencing. He is here with counsel, Mr. Steve Preble, State of Indiana by Gary German.
Good morning, Mr. Seymour. Can you hear me okay?
Yes, sir.
Sure. I've got a one-page document here entitled Recommendation of Disposition, which appears to bear your signature down along the left-hand side. Did you sign this?
Yes, sir.
Did you read it before you signed it?
Yes, sir.
Did you have a chance to speak with your attorney before you signed it?
Yes, sir.
And before you signed this, do you believe you understood its contents completely?
Yes, sir.
As I understand it, you plan to admit to violating your probation, and upon so doing, you'll be sentenced to 10 months in the Porter County Jail with none suspended, be released unsatisfactorily from probation for this case only, and there'll be judgment liens entered for any unpaid fines, fees, or costs. Is that your understanding of the disposition?
Yes, sir.
You realize if you admit here, you'll be waiving your right to a hearing where the state would have to prove by a preponderance of the evidence that you actually violated your probation.
Yes, sir.
And you'll be waiving the right to confront and cross-examine witnesses and to use the court subpoena powers to have witnesses brought here to testify on your behalf. You understand
Yes,
that?
sir. Yes, sir.
And with that in place, you'd still like to admit?
Yes, sir.
And you admit then, Stevie, that you removed your ankle bracelet, the electronic monitoring device for home detention?
Yes, sir.
Okay, sir. I'll accept your admissions. Finally, you violated your probation, accept the recommendation of disposition, and sentence you in accordance with the terms of your agreement. Okay?
Yes, sir.
Good luck to you, sir. We're adjourned. I don't know.
It should be, I've got him in since January 20th, Your Honor, so it should be time served.
Yeah, I mean, I don't disagree with that. January 20th, I'll have to pull it up here.
I agree.
Okay.
That's the correct date.
We're adjourned, sir.
Oh,
I
thank
think you'll be released from jail today on this charge. I don't know about your other situations.
you. Okay.
Kayla Smith, state, would you please set a record?
Yes, Your Honor. Thank you. This is State of Indiana versus Kayla Smith. There are two cause numbers, 64D012507F67655, 64D012606CM6093. Defendant appears in court in person by video conferencing with counsel, Mr. Steve Preble, State of Indiana by Gary German.
Morning, Ms. Smith. Can you hear me okay?
Yes, Your Honor.
I have a one-page document here entitled Recommendation of Disposition. The document appears to bear your signature down along the left-hand side. Did you sign this?
Yes, Your Honor.
Did you read it before you signed it?
Yes, Your Honor.
Did you talk to your attorney about it before you signed it?
Yes, Your Honor.
Before you signed this, do you believe you understood its contents completely?
Yes, Your Honor.
Okay, I didn't put Stevie under oath, but I probably should do that. Ms. Smith, please raise your hand to be sworn. You swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, Your Honor.
Okay, thank you. This says that you plan to admit to violating your probation, and upon that admission, you'll be sentenced to time served in the Porter County Jail as of today. Upon your release, you'll return and complete probation as previously ordered. The time for your probation will be told, and the case with short cause CM 6093 would be dismissed. Is that your understanding of the disposition?
Yes, Your Honor.
You realize if you admit here, you'll be waiving your right to a hearing where the state would have to prove by a preponderance of the evidence that you actually violated your probation?
Yes, Your Honor.
You'll be waiving the right to confront and cross-examine witnesses and to use the court subpoena powers to have witnesses brought here to testify on your behalf?
Yes, Your Honor.
And with that in place, you'd still like to admit?
Yes, Your Honor.
Did you use drugs while you're on probation?
Yes, Your Honor.
And you were also arrested for new charges while you're on probation?
Yes, Your Honor.
All right. The court will accept your admissions. Finally, you violated your probation, accept the recommendation of disposition, and sentence you in accordance with the terms of your agreement.
Thank you.
Hey, I need you to meet with probation today.
Yes.
Okay, so Kayla, if you could go over to the probation department and meet with Ruth today.
Okay, but I have a warrant for Marshall County.
Where?
Marshall County, it was because when I got arrested, I wasn't able to sign up for probation.
I don't show a warrant. Jill, do you have a hold on her?
I do not at this time, Your Honor.
Oh, so I can leave? Okay.
I don't see it. Go to probation unless you have to go to Marshall County. Ms. Garrett can figure that out if you don't come through.
Okay.
Okay,
Thank you, Your Honor.
all right. Richard Steffen, state, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Richard Steffen. The cause number is 64D01-2404F63438. Defendant appears in court in person by video conferencing with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
Morning, Mr. Steffen. Can you hear me okay?
Yes, Your Honor.
Sir, I've got a one-page document entitled Recommendation of Disposition, which appears to bear your signature down along the left-hand side. Did you sign this?
Yes, Your Honor.
Did you read it before you signed it?
Yes, sir.
And did you have a chance to speak with your attorney before you signed it?
I did.
Before you signed this, do you believe you understood its contents completely?
Yes, Your Honor.
Please raise your hand to be sworn. Do you swear affirm under penalty of perjury to tell the whole truth and nothing but the truth?
I do.
Okay, thank you, sir. It says here you plan to admit to violating your probation. And upon that admission, you'll be sentenced to time served in the Porter County Jail through August 12th of 2026. You'll complete the Porter County Jail CDA program, be released unsatisfactorily from probation, and then we'll enter judgment liens for unpaid fine, fees, and costs. Is that your understanding of the disposition?
Yes, Your Honor.
You understand if you admit here, you'll be waiving your right to a hearing where the state would have to prove by a preponderance of the evidence that you actually violated your probation?
Yes, Your Honor.
You'll be waiving the right to confront and cross-examine witnesses and to use the court's subpoena powers to have witnesses brought here to testify on your behalf?
Yes, Your Honor.
And with that in place, you'd still like to admit?
Yes, Your Honor.
All right, Mr. Steffen. It says here you've failed multiple drug screens. Did you use methamphetamine while you're on probation?
Yes, I did.
And you also didn't participate in our Porter County Alcohol Drug Offender Service Program. Is that correct?
Correct.
All right. The court will accept your admissions. Finally, you violated your probation, accept the recommendation of disposition, and sentence you in accordance with the terms of your agreement. Mr. Steffen, I've had this, I don't know how many times before, 3 or 4 times before, where I've done this exact same deal where you are supposed to do the CDA program, and for whatever reason, the defendant goes back to the CDA program and doesn't complete it. Okay? That's a terrible result because then we don't know what to do, and then you sit in jail longer than what you had planned to sit in jail. Okay? So let's finish that CDA program. All
I'm
right.
all
All right. And I don't think I'm going to be around on the 12th of August. I can't make it out to your graduation, but I know the prosecutor makes every effort to get out there to see you. I've got to go to Washington. So I won't be here on the 12th of August. But I wish you the best of luck, sir. Okay?
I appreciate that, Your Honor.
All right. We're adjourned.
Oh, interesting. What's he going to do in Washington?
Steve, let's do Janae Ross.
Yes.
State, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Janae Ross. Cause number is 64D01-2509F61067. Defendant appears in court in person with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
Thank you, sir.
Margaret, hello.
Ms. Ross, for purposes of the change of plea, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
You can put your hand down. Please state your full name for the record.
Janae Nicole Ross.
Have you ever gone by any other name?
No, sir.
All right. Give me just a second while your file comes up here. How old are you?
24.
The court has been informed that you wish to change your plea to guilty on count 1 theft, a level 6 felony. Is that correct?
Yes.
Before I can accept any guilty plea, I need to ask you some questions. But anytime you don't understand a question, let me know and I'll explain. But anytime you'd like to speak with your attorney before answering, let me know and you'll be allowed to do that. Have you ever been treated for any mental illness, or do you now suffer from any mental or emotional disability?
No, sir.
Are you currently under the influence of any alcohol or drugs?
No, sir.
To count one, theft, a level 6 felony, how do you now plead?
Guilty.
Can you say it so that the sound system picks you up, Ms. Ross?
Guilty.
Thank you. Ms. Ross, you have the right to a public and speedy trial by jury. Do you understand that?
Yes, sir.
You have the right to face all witnesses against you, to see, hear, question, and cross-examine those witnesses. Do you understand that?
Yes, sir.
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
Yes, sir.
The state of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. Do you understand that?
Yes, sir.
You cannot be forced to make any statement or to testify against yourself at any hearing or trial, but have the right to remain silent. Do you understand that?
Yes, sir.
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. Do you understand that?
Yes, sir.
By pleading guilty, you're giving up all of the rights that I've just gone through. Do you understand that?
Yes, sir.
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or any future time, the court would appoint one for you. You understand that?
Yes, sir.
By pleading guilty, you're admitting that everything the state would have to prove beyond a reasonable doubt for you to be found guilty is in fact true. You understand that?
Yes, sir.
By your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
Yes, sir.
If you're not a citizen of the United States, a conviction of these charges may change your immigration status. You might either be in a less favorable immigration status or subjected to being deported from the United States. You believe that'll be a problem for you in this case?
No.
Okay. The possible penalty, I have to ask everyone. The possible penalty for a level 6 felony is from between 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, sir.
If you have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. Do you understand that?
Yes, sir.
Are you currently on parole or probation anywhere?
No, sir.
Other than this case, are you out on bond on any charges anywhere?
No, sir.
This plea of guilty may cause harsher sentences for any future crimes. Do you understand that?
Yes, sir.
Court received a 4-page document entitled Recommendation of Plea Negotiation. The document appears to bear your signature right at the top of the 4th page. Did you sign this agreement?
Yes, sir.
Did you read it before you signed it?
Yes, sir.
Did you have a chance to speak with your attorney before you signed it?
Yes, sir.
And before you signed this, do you believe you understood everything in it completely?
Yes, sir.
As I understand the sentencing portion of the agreement, you'll be sentenced to 540 days in the Porter County Jail with all but time served suspended. You'll spend the balance on formal probation and pay the related fees. There's an amount of restitution, $150, that's due at the time of sentencing. Upon successful completion of your term of probation, you may request judgment be modified to a Class A misdemeanor. State, the
Yes.
box under subsection,
That
Four,
should not be there.
okay, should I just take the X out completely?
Yes, yes, please.
All right. Mr. Pribble, any problem with me striking through, or I'm going to white out the X that's found under subsection 4H?
No objection, Your Honor. I believe that's consistent with 4F, so we agree.
Right. Yeah, Ms. Ross, you understand what I'm doing here? This says you're going to pay restitution in the narrative portion under subsection 4F, and then under 4H, where they talk about restitution, the box is checked saying there is no restitution. I'm just going to strike through that X so that there's no confusion. Okay. And you don't have a problem with that?
No.
Okay, thank you. Do you have the 150 today?
Just, there's a cash bond and
Oh, to work for that?
yes.
Okay. All right. Is that the entirety of the sentence as you understand it to be?
Yes, sir.
You realize I'm not a party to this agreement, but if I choose to accept it, I'll be bound by its terms at your sentencing and with respect to any future sentence modification?
Yes, sir.
Okay. You know you'll get credit for your time served awaiting disposition of this case? Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
No, sir.
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
No, sir.
Your attorney's going to ask you some questions to establish what we call the factual basis for your plea. Please give him your attention. Mr. Pribble,
Thank you, Judge. Janae, on July 6th.
can you grab the mic, Steve?
Yep, sorry. Janae, on July 6, 2025, did you knowingly or intentionally exert unauthorized control over property belonging to a Ms. Sarah Puckett?
You guys have to share the mic. I apologize.
Yes.
And you did so by withdrawing funds from her bank account by using a PayPal account, is that correct?
Yes, sir.
And did you have her permission to do so?
No, sir.
And you intended to deprive her of any part of that property or its value or use, is that correct?
Yes, sir.
And did these events occur within the boundaries of Porter County, Indiana?
Yes, sir.
Thank you, Janae. I have nothing further, Your Honor.
Okay, thank you. State.
No questions, Your Honor. Would offer the affidavit of probable cause as further support of the factual basis.
We'll show that admitted insofar as it applies to count one. I guess I should clean up that in subsection 4B, it says state will dismiss the following, and it doesn't say count two.
Judge, I dismissed that on October 24th.
Oh, okay, it just still shows up in my header. I apologize. All right. I don't have any additional questions. Court finds the defendant understands the nature of the charge against her to which she's pled guilty, that she understands the possible sentence for that charge, that her plea has been made freely and voluntarily, and there's a basis in fact for the plea of guilty. Shall we move into sentencing then, sir?
If we may, Your Honor, I waive pre-sentence, have no additional evidence or argument.
Okay, I will note the waiver and accept that. We can move forward with sentencing. Mr. Pribble, any evidence or argument for sentencing, sir?
No evidence or argument, Your Honor. Thank you.
Okay, thank you. Ms. Ross, this is your chance to say whatever you might like to say. Before I rule on the case, would you like to exercise that right, ma'am?
No.
Okay, well, at this time, the court is happy with the plea that's been negotiated between the parties. I appreciate the hard work to bring this case to a resolution. I will accept the recommendation of plea negotiation, enter judgment of conviction on count one, theft, a level 6 felony, sentence you to 540 days in the Porter County Jail, suspending all but time served. You'll spend the balance on formal probation and pay the related fees. There's the amount of restitution, $150 due at the time of sentencing. We'll take that from your bond. Upon successful completion of probation, you may request judgment of conviction be modified to a Class A misdemeanor. Looks like the arrest warrant was served October the 2nd. So on our bond form, it doesn't specifically say the date that the agreement was entered into. It's file marked October the 3rd. Did you bond out the same day you were arrested? Or did you have to spend the night in jail?
No, I didn't get arrested. I looked on my case and seen, and I just went and turned myself in.
So you turned yourself in and bonded out at the same time? Okay. So that's consistent, I think, with the record here. We'll show a day time served on October the 2nd of 2025. Cash bond was posted by, you posted your own bond.
Yes, sir.
Okay. So from the cash bond, the court will retain court costs, probation, initial administration fee, jail booking, sheriff's death benefit fee. We'll retain the $150 restitution, and the remainder will be refunded to Ms. Ross. I can't exactly read it. I think 3425 Elm Street.
No, it should be a different.
What's your address now?
1236 West 17th Avenue, Gary, Indiana.
1236 West 17th.
Avenue,
I got you.
apartment 3.
Apartment 3.
46
Gary. Can we get the zip code again?
46407.
46407?
Sir,
Okay, you're very soft-spoken this morning, Ms. Ross.
I'm tired. Sorry, I got off work at 4:30 in the morning.
I just want to make sure you get your money back. Is there anything further then?
No, Your Honor. Thank you.
No, Your Honor, thank you.
From here, I need you to go to the probation department. You know where that's located?
Oh, sir.
Yeah, 157 Franklin Street. Veer left down the sidewalk on your way out of the courthouse, halfway down the block, past the elections office on the left-hand side. You can't miss it. Get signed up for probation, okay? And I wish you the best of luck.
Thank you.
We're adjourned. Demarion Thames, state, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Demarion Thames, cause number 64D012409F6100551. Defendant appears in court in person by video conferencing with counsel, Mr. Steve Pribble. State of Indiana by Gary German.
Morning, Mr. Thames. Please raise your hand to be sworn. You swear affirm under penalty of perjury to tell the whole truth and nothing but the truth.
Yes.
Sir, I have a one-page document. Thank you. I have a one-page document here entitled Recommendation of Disposition. The document appears to bear your signature down along the left-hand side. Did you sign this?
Yes.
Did you read it before you signed it?
Yes.
Did you have a chance to speak with your attorney before you signed it?
Yes.
And before you signed this, do you believe you understood its contents completely?
Yes.
As I understand it, you plan to admit to violating your probation, and upon so doing, you'll be sentenced to return and complete probation as previously ordered with the probation time told. Is that your understanding of the disposition?
Yes.
Okay. You understand if you admit here, you'll be waiving your right to a hearing where the state would have to prove by a preponderance of the evidence that you actually violated your probation?
Yes.
You'll be waiving the right to confront and cross-examine witnesses and to use the court's subpoena powers to have witnesses brought here to testify on your behalf. You understand that?
Yes.
And with that in place, you'd still like to admit?
Yes.
All right, it says here that you tested positive for marijuana during the probation term. Did you use marijuana
Yes.
while you're on probation?
Yes.
Okay, we'll accept your admissions. Finally, you violated your probation, accept the recommendation of disposition, and sentence you in accordance with the terms of your agreement. Are you going to be able to stop using marijuana?
Yes.
You need any help with that?
No.
Your probation officer can give you all kinds of recommendations about treatment programs and different ways to help you stay clean. Do you understand that?
Yes.
Okay, because I'm not going to tolerate it. You realize that?
Yes.
That if you were in prison, you wouldn't be using marijuana. You realize that?
Yes.
And the next stop after you keep using marijuana, if you choose to, is going to be prison. And that's not where you want to be, is it?
No.
Okay, so stop smoking dope. Okay? Or using THC or whatever you're doing. Acknowledge.
Okay.
Okay, thank you. We're adjourned.
Judge, I think
Good luck.
I think he needs to go see this probation officer.
Yeah, she's online. Kim, do you want to see him?
No, we have an appointment next week, so next week's fine.
Make your appointment with your probation officer next week. She's going to drop you for a drug screen as well.
All right.
All right.
Thank you.
Thank you, Mr. Pribble.
Thank you, Judge.
I gave you my sheet, Judy. I don't know.
I have an extra, if I may, please.
I don't know where it went. I've trashed up my desk. Oh, well. Let's take Nicholas Pruitt. State, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Nicholas Pruitt, cause number 64D012309F68052. Defendant fails to appear. In his absence, the State of Indiana requests the issuance of a bench warrant for the defendant's arrest for failure to appear.
Judy has news.
Same motion.
Yeah, we'll grant the state's motion, issue a bench warrant for Mr. Pruitt's arrest. It's not really funny. That's what we'll do. We'll give him a ride over, just to be safe. Dorothy Gilbert, state, would you please set a record?
Yes, thank you, Your Honor. This is State of Indiana versus Dorothy Gilbert, cause number 64D012606F66118. Ms. Gilbert appears in court in person without counsel. State of Indiana by Gary German.
Hey, Ms. Gilbert, last time you were here, you told me you planned to hire counsel.
Yes,
How's that going for you?
it's not. I did file a motion for, to request a public defender, but they told me to just come in. I was downstairs by the clerk's office. They told me to come up here and talk to you. I filled out the paper.
Okay, I don't need a written motion for that. Please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thanks. What do you do for work?
I was a bartender, so I'm just looking for more work.
Are you currently bartending?
In between, two of them right now, PJ's and Rusty Nail.
So you bartend at two places?
Yeah.
Oh, okay.
I'm trying, I'm just trying to get my rent and car and stuff. I just went through a divorce, so just a lot going on.
Yeah, I understand. How much do you earn as a bartender?
One of them pays $5 an hour, the other one's $6. And that
Sure,
depending on tips.
but that's not where the money's at, right? You're making money as tips?
Yeah.
How much tips are you doing each week?
It depends on the crowd, like bingo night's a good.
Yeah, I understand, Ms. Gilbert, but what's a normal week look like for you?
I'd say like $100 a week.
$100 in tips a week?
Yeah,
So that's why you're looking for a new gig, huh?
yeah.
Right. You say you have a car payment?
No,
No?
I don't have a car. My ex-husband got the car.
Okay, how do you get around?
My friends,
You say you're trying to make your rent, though?
Uber, Lyft.
You say you're trying to make your rent?
Yeah.
How much is your rent?
There it will be about 1,000, including NIPSCO.
Okay. Does anybody live with you?
No,
Your kids?
no,
Do you have kids?
yes.
How many?
I have 5, but my husband, they live with my ex-husband.
Okay, are you paying support?
Yeah, yeah. We just went through court and stuff. It was
You
fine.
pay support?
Well, I'm supposed to.
How much?
I think it was 72 a week.
How far behind are you?
I'm not.
You're not.
No.
Are you on any form of public assistance?
Yes,
What do you have?
I have food stamps for them and insurance through the state.
All
I
right,
just
I'll
got-
find you're indigent, you qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. And you already have an omnibus hearing set on August the 14th at 9 and a pretrial conference set on September the 18th at 9. You're ordered to appear for both of those.
Yeah.
And this guy behind you will be your public defender. If you want to contact his office, his phone number is on the sheet right there today, and they can get you on his calendar.
Okay,
You need to get working on your defense. You have some deadlines that expire on July the 14th that you're going to want to be careful about, okay?
okay.
All right, we're adjourned.
Thank you.
Good day.
Too.
How can I help?
I have Ms. Staton.
You do? State, would you please show the record for Jessica Staton?
Yes, Your Honor, thank you. This is State of Indiana versus Jessica Staton. There are 2 cause numbers, 64D01 2603F6 3164, excuse me, and 64D01 2209F6 7597. Defendant appears in court in person with counsel, Mr. Steve Provo, and I believe Ms. Remley is also counsel in one of these cases, Your Honor. State of Indiana by Gary Germ.
I don't see Ms. Rimley here.
Oh, you-
And back on June 5th, temporary Judge Katsademus granted her permission to appear by Zoom today. And she does not appear. We'll issue in this order, add a sentence about how she can come show cause for her failure to appear. We'll have that in the next hearing. Mr. Purple, how can I help?
Your Honor, I know Ms. Staton is working diligently with regard to treatment options, so I haven't yet been able to speak with Mr. Gurman while that process has been going on. So I just need a new court date, maybe sometime in August.
Okay. So, Ms. Garrett, I don't have any new revocation matters since the June 5th hearing. Is that right?
I believe that is, well,
I see the 4th addendum that was filed on June the 1st. My assumption was, I guess, that temporary Judge Katsademus had gone through that with Ms. Staton.
I believe the answer is yes, Your Honor.
I mean, it makes sense, given the timing. I'm going to assume that she has advisement. Ma'am, you understand that the 4th addendum to the petition for revocation was filed back on June 1st, 2026, and that it talked about out-of-jurisdiction travel, that you went to a treatment program in Chicago, Illinois without a travel permit and all that?
Yes, Your Honor.
And you were aware that that was part of the revocation proceedings here?
When I had court, yes, Your Honor.
Okay. I thought that the temporary judge who was here for me 3 weeks ago probably advised you about that, but
Yes, Your Honor.
it's not as clear as I would love for it to be. But you believe you understand the allegations there
Yes, Your Honor.
and your rights and responsibilities related to the petition for revocation of probation?
Yes, Your Honor.
That's fine then. Okay. Yeah. Mr. Pribble, how much time do you think?
Well, probably next available, Your Honor. I just don't know if July. I know July is pretty tight. That's why I thought August might be.
July 31st is great
Oh, that's fine.
because I can't get her in then again until August 21st. So let's do July 31st. Any problem with that, State?
No, Your Honor.
All right. So, man, we'll see you back on July 31st at 9 a.m. in order to appear back here at that date and time.
Thank you, Your Honor.
What are you doing for your recovery now?
Well, right now I joined IOP classes at Porter Stark. I got the paperwork. I start July 6th. It's going to be 3 days a week. And I've been going to meetings. I got signatures to show you guys. I went to like 3 a day. And that's all. I'm going to the methadone clinic every day, and I have counseling and therapy through that as
Was that
well.
through Porter Stark as well?
Yeah, everything's through Porter Stark. I have all the paperwork for you guys. And I
Okay.
did a release for my.
Yeah, make sure you share that with Ruth. Does she have an appointment with you?
I want to see her today.
All right. So you're going to meet her in the hallway?
I'm going to meet her at my office.
Awesome. Go with Ruth over to the probation department.
Thank you, Your Honor.
We're adjourned. Thank you. Anything else, Mr. Pribble?
Oh, that's it, Your Honor.
All right. Have a fantastic weekend. Ivan Dinkovsky, what do you need? No, he can turn himself in at the jail. Ivan Dinkovsky, State, would you please set a record?
Yes, Your Honor. Thank you. This is State of Indiana versus Ivan Denkoski, cause number 64D01-2502F61498. Defendant appears in court in person without counsel. State of Indiana by Gary Gurman.
Are you Carlos Robinson? All right, I'm going to go through an advisement of rights with Mr. Dinkovsky. Listen to that, okay? You're going to get the same thing. I'm just going to ask you if you understood the advisement when you come up next, okay? All right, so first I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you cannot be forced to make any statement or testify against yourself at any hearing or trial held in this matter. Do you understand those rights as I've just gone through them?
Yes, Your Honor.
Okay. So you've been charged here with one count, theft, a level 6 felony. The cause states that on January 16th, 2025 in Porter County, you did knowingly or intentionally at the Bass Pro Shop exert unauthorized control over miscellaneous electronics belonging to Bass Pro with the intent to deprive Bass Pro Shop of any part of the property's value or use. But the value of the property was over $750. They state a value here of $1,449.95. You understand the allegations in count one?
Yes, Your Honor.
It's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, Your Honor.
As required by statute, the court will enter a preliminary plea of not guilty for you on count one. Do you plan to hire a lawyer in this case?
Yes, Your Honor. Like, I just got out from prison, and if you can give me like a month or so, like, I will hire a lawyer.
Okay, I'll give you 2 weeks.
2 weeks.
Yeah, I'll show that you plan to hire private counsel. Let me set you up for a couple
it-
hearings. The first one's going to be on July the 10th. Well, you'll come back and let me know what progress you've made hiring counsel. And then I'll set you up for an omnibus hearing on August the 14th at 9 a.m. and a pretrial conference on September the 18th at 9 a.m. You're ordered to appear for both of those, okay?
Okay.
All right, and we'll give you a note. Do you have any questions about anything?
So I have to show up on the July
10th,
10th,
9 a.m.
and then with the lawyer.
Well, if your lawyer gets in the case before then, they'll enter their appearance and usually they ask to vacate that July 10th date, but work with your attorney.
Okay, because I will need like maybe a month just to get some money together to hire a lawyer.
I understand, Mr. Dinkovsky, and if you can't do it before July the 10th,
Okay.
come back and we'll have another chat.
Okay, thank you, Your Honor.
Yeah, and you see the note?
Yes.
It has the dates, right?
Okay, yeah.
We'll see you then. We're adjourned.
Thank you.
Good day, sir. Carlos Alexander Robinson, State, would you please set our record?
Yes, Your Honor. Thank you. This is State of Indiana versus Carlos Robinson, cause number 64D01-2603F63404. Defendant appears in court in person without counsel. State of Indiana by Gary Gurman.
Morning, Mr. Robinson.
Good morning.
Were you in court a few minutes ago when I read through some rights with another defendant?
Yes, sir.
Do you believe you understand your rights in this matter, sir?
Yes, sir.
All right. You've been charged here with one count, theft of a motor vehicle, a level 6 felony. This cause states that on March 26, 2026, at 2218 Gina Street in Portage, you exerted unauthorized control over a 2018 Kia Sportage belonging to victim 1, and you took that vehicle and intended to deprive the owner of any part of the property's value or use, and the property, as mentioned, was a motor vehicle. Do you understand the allegations in count 1?
Yes, sir.
And it's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. Do you understand that possible penalty?
Yes, sir.
As required by statute, the court will enter a preliminary plea of not guilty for you on count 1. Do you plan to hire a lawyer?
No, sir.
Are you asking me to see whether you qualify for the public defender?
Yes, sir.
Please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
What do you do for work, sir?
Where do I work?
What do you do for work? Yeah, where do you work?
Oh, I'm not employed at, I used to be employed at Taco Bell, but I just lost my job 3 weeks ago. So I'm trying to get back into another location. When I talked to the GM, he's trying to put in the word at another location because I'm not rehireable at the location that I was at.
Okay, so if you're working at Taco Bell or some other fast food place, how much would you be earning each hour?
Well, weekly, I was bringing $567 home before I cut hours, but afterwards, when I was getting 40 hours, it was $724, I want to say.
And that 567 was your take-home pay?
Yes.
So, do you have any kids?
Yes.
How many?
5.
Are they all in your care and custody?
No, just 2.
Okay. For the other 3, are you supposed to pay child support?
For 2 of them, yes.
What about the third one?
No, it hasn't been established yet.
Okay, but it's still your responsibility to have financial responsibility for the child?
Yes, sir.
Okay. Does anybody live with you?
Yes.
Who is it?
Stacy.
Okay.
She's my girlfriend.
Does she help you with the bills and things?
Yes, sir.
How much is your mortgage payment or your rent payment?
It's $1,500 a month.
And she helps you with that?
Yes.
Is it rent or a mortgage?
No, that's rent.
Do you have a car?
No, she does, yes.
Is that how you get around?
Yes.
How do you get around when she's working or whatever?
I'm at home with my daughter.
Okay. Do you own any big ticket property items of your own, like a boat or a big diamond ring?
No.
Okay, anything you could sell so you could hire a lawyer?
No, I mean, I have a laptop, but I mean, it's not going to equivalence to a lawyer fee.
I understand, sir. I appreciate your honesty. Are you on any form of public assistance, you or your children?
No, right now I'm trying to get assistance right now.
Unboxing is going really weird, V. So I find everything I don't need and cannot find anything that I do need.
Okay, you're looking for food stamps?
Well, not really food stamps. Well, with rent and maybe food. They said I didn't qualify for the food because at the time we both were working. So they making us redo the steps. So we're trying to get the steps going again. We made too much at the time, so they kept denying us.
I understand. Are you on state insurance?
Yes.
I'll find you indigent. You qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. And I'm going to set you up for a couple of hearings. The first one's going to be an omnibus hearing on August the 14th at 9 a.m. Second one's a pretrial conference. That'll be on September the 18th at 9 a.m. in order to appear for both of those, and we'll give you a note. Okay?
Thank you, sir.
You have any questions about anything?
I can't leave the state of Indiana or anything?
I mean, you should talk to your lawyer about that.
Okay.
But preferably you get permission to do that, but you should talk to your lawyer about it.
Okay.
Okay.
Thank you.
All right. Good day.
You too.
Okay, let's move to Judge Riggins. Nobody exploded in Michael Fisher's courtroom, but that's okay.
So there's copies of your charges, copies of your report, police report, and copy of your reminder to come back, okay? All right, free to go, Corey. Thank you. Mr. Reinhardt. State has offered you a deferral, $234. Is that something you can pay today? You have the cash on you? Very good. All right, I will give you a copy. Just go down to the clerk's office, pay it, bring me back the receipt. Do you graduate? Did you graduate this year? Where are you going to school? What are you going to study? Good friend of ours just graduated from Purdue with actuarial science. It's a good degree. Two of my sons have been at Purdue. One graduated, one's still there. There's police officers at Purdue. There's also drinking at Purdue. And the prosecutor's office in Tippecanoe County is going to know you got this deferral. You're not going to get a second one, probably. You understand that? So you have worked yourself in a situation where you need to behave probably better than the average typical freshman at Purdue. You understand that? You doing Gold Rush? No? Why not? I think you ought to, it's not too late. I think you ought to do it. My boys have enjoyed it thoroughly. So it's a good time to get to know other students and all that and get you acclimated to school better. All right, go down and pay that and bring it back to me. All right. All right. Tyler, are you ready? The one in custody. And then Mr. Banks, I'll do your guy next. So. Gary, come on up. Thank you.
Throwing ourselves on the
Okay. Great.
testimony.
Very good. Raise your right hand, Carrie. You affirm under pain and penalties of perjury testimony you're about to give is the truth, the whole truth, and nothing but the truth. All right. Tell me your name. This is 73 DO2 2605 F6 169. It's my understanding you're going to plead open to count 1, possession of methamphetamine, count 2, possession of a narcotic drug, count 3, unlawful possession of a syringe, count 4, driving while suspended, and count 5, operating a vehicle while intoxicated. Is that correct? First 3 counts are level 6 felonies. Those are punishable from 6 months to 30 months. The advisory sentence.
She's pleading open to Riggins. So Riggins is slightly like Middleton. So it's a small town. He knows everybody. Everybody knows him. I guess I don't know her circumstances, right? But if he's given her chances before and she messed them up, there's no chance I would plead open to Riggins. None. But if this is her first time in front of him, I don't know. It might be okay. I don't know. We'll see.
It's 12 months. Depending upon your past criminal history, you could get it knocked down to a Class A misdemeanor. The level 6 felonies, I could stack them, but not more than 4 years. Misdemeanors, I could stack, but not more than 3 years. Do you understand that? All right. Well, it'd be not more than 2 because there's only 2 of them. So the minimum sentence is 6 months. The maximum is 5 years. Do you understand that? When you plead guilty, you give up constitutional rights. You give up the right to an early public trial. Here in the county where the offense occurred, you give up a right to trial to the bench or to the jury. Right now, we were set for a jury trial. Could have had a bench trial too as well, but at that trial, you would have been presumed innocent. You'd have had the right to remain silent. You'd have had the right to have the state prove your guilt beyond a reasonable doubt. You'd have the right to confront and cross-examine witnesses against you and to subpoena witnesses to testify on your behalf. You'd have the right to appeal any conviction entered against you as well as any sentence imposed upon you. Except for appealing the sentence, you're giving up all those rights. Do you understand this? Has anybody forced, threatened, or coerced you to do this? Has anybody promised you anything? This is what you want to do. Are you sober today? Is there anything about you mentally, emotionally, or physically stopping you from understanding what you're doing today? Are you on probation or parole? Do you have cases pending anywhere else? You went over this case with Tyler. Are you happy with his services? Is there anything you wanted Tyler to do he has not done? Okay. Then I'll find your waiver of your trial to be no intelligent voluntary. How do you plead into possession of methamphetamine as a level 6 felony? Guilty or not guilty? How do you plead to possession of a narcotic drug as a level 6 felony? Guilty or not guilty? How do you plead to unlawful possession of a syringe as a level 6 felony? Guilty or not guilty? Was the syringe normally a level 6 felony? But because of a prior or it is? Okay. All right. For some reason I was thinking you had to have a prior, but all right. Count 4, how do you plead to driving while suspended as a Class A misdemeanor, guilty or not guilty? And how do you plead to operating a vehicle while intoxicated as a Class A misdemeanor, guilty or not guilty? All right, so on May 22nd of 2026, you were driving, operating a motor vehicle in the streets of Shelby County, Indiana. Is that correct? You were impaired, correct? You were impaired to the extent where you were intoxicated, correct? You were impaired on alcohol or drugs or both? Drugs. Now, there was a blood test drawn, correct? And we don't know the results of that. You understand that? And we're never going to know the results of it because that's going to call the lab and say, hey, you know what? She pled guilty. Forget about it. We don't need it. You understand that? But you know your condition that day. And you know you were impaired, correct? You were impaired by what? Methamphetamine? Marijuana? Okay. So at some point you possessed THC. Is that correct? Did you also possess methamphetamine? Did you also possess a narcotic drug? What was the narcotic drug? Heroin? Okay. How long have you had a heroin?
Used heroin at least within the last day, too.
Yeah.
So we have no doubt the metabolites would be blood, correct?
Okay.
Sorry, guys.
All right, that's fine. I appreciate that. Now, first of all, you should have been driving anyway because you were suspended, correct? And you knew you were suspended, correct? And you had a prior conviction for driving while suspended within the past 10 years of May 22nd of 2026. Is that correct? You had a syringe, correct? You used the heroin used the syringe to ingest the heroin, correct? And that's why you possessed it, correct? The syringe. All right. And these events all occurred in Shelby County, Indiana, correct? Yep. Very good. All right. Upon your plea of guilty, then I will find you guilty. I find your plea to be knowing, intelligent, and voluntary, and there is a factual basis in your judgment and conviction for counts 1 through 5 as previously discussed. All right. I take it you have some testimony. You waived PSI.
We do. Currently under oath, correct? Tell the court how old you are.
You said 30?
Substance abuse. Your judge talk about heroin and meth.
Yes.
How long have you been abusing heroin and meth? Since you were 18. Why'd you start when you were 18?
My grandpa died, my grandma died after that. My dad died, my uncle died.
So
Were these all overdoses or something like that, or just?
My dad died of emotional birthday. I'm here with either done. He died within 6 weeks. He was supposed to in the last 6 years. My grandma died of her day. She was 74. My uncle just died in his sleep. We think it had something to do with it. They got diagnosed with the long-term symptoms.
Yeah.
Just like horrible, like it's on my face.
So did you live with these individuals?
Yeah. Me and my grandma have always been close to my grandpa was there. And I'll be good every weekend and every summer. I hope to get my grandpa out of the doctor.
So you had no issues
Hi,
with any kind of
Terry.
substances prior to that? Who introduced you to the heroin? Okay, I'll just continue, Tyler. Yeah.
And you've been using for the last dozen years, correct? And on that terrible path of substance abuse, you've acquired a number of criminal convictions as well, right? This isn't your first entry into criminal court. You have prior felonies,
Yes, sir.
prior misdemeanors.
Yes, sir.
Let the court know what your criminal history is like.
Possession of the possession of the land, possession of I believe we never heard of
You have children? How old are they? Where are they currently living? Told me something in jail. Just over this slide, all right? You said, hey, Tyler, I want to plead guilty. I want to get this case over with. Is that correct? Yes. Been incarcerated since May 22nd. So today would be day 35. Right? That's after a dozen years of using very hard drugs. We appreciate that it's miraculous that you're alive.
Yes, sir.
Also, reading the probable cause, 22nd of May, your driving behavior, I'm sure Mr. Zick is going to mention it.
Thanks for
Very
reminding me.
It's very, very dangerous, right? Deputies coming to the scene, he expects that there's a wreck, this traffic is stopped. There wasn't a wreck because two tractor trailer semis stopped traffic, so you couldn't keep driving. They come upon you, correct? Reading the probable cause.
2 semis stopped her from driving. Oh my God.
You comply. They, I think they asked you if you've used recently. You said, yeah, the last day or so or something like that. You consent to the chemical test. You appreciate that it's also very fortunate, one, that you've not overdosed in your history of substance abuse, that nobody was hurt because of your driving. One question I want to ask you: do you have any prior operating level intoxicated convictions? Not to your knowledge. So we get arrested. You've been at jail. How have you used your time while at jail?
I've been participating in the recovery program of women's victims of actually I've been doing the Jennings and Marching program.
No, I did not forget.
I'm on step 4 and marching. Other than that, I just really spent my reading for a lot of it.
You've been in contact with jail employee by the name of Rodney.
Yes.
He's helped you look into places where you can go to rehab.
Yes.
Today we're asking the judge either allow us to rehab, correct? Or get us screened for JIP. One of the two.
Probably leaning towards a JIP, to be honest. That's kind of where my mind was going.
And very good. When you complete JIP, you understand you have to go to an admin here. So, correct. What facilities are you spoken to? Stranges and greens, correct.
Here as long as it was within my insurance and my friend and strange, so they would take me right after I got out of the
So what we're asking is, we want drug treatment one way or the other, right? We want a sentence that is partially suspended, where we'd be on probation or home detention. So we're monitored, and as a condition of that suspended sentence, we participate in whatever drug treatment. A fair summary of what we're asking. Okay. Is there anything I failed to ask you that you think the court should know? No other questions.
Mr. Zick?
So you were doing a lot of drugs that night, weren't you?
Make sure you speak up. Your soft-spoken Ed's got to be able to hear you, okay?
Okay, so let's see, they found syringes in the vehicle, is that right? It looks like they found a white piece of paper that tested positive for methamphetamine. Okay, and then there was a piece of folded tinfoil with a brown powder on the substance. And then potentially it was heroin, but then they tested another folded piece of paper, and that tested positive for methamphetamine. Yes. And then there was inside the purse, there were silver spoons with one side burnt black, several pieces of tin foil, and a tourniquet. Is that right? And then inside the bag was, it looks like Delta 8, Delta 9, dummies, and things like that. Remember that? Yes. So suffice to say, you were based on a veritable cocktail. Correct? Is that right? Yes. You would agree with me that your driving was not too dangerous because you're extremely dangerous. Correct? I mean, looking at the probable cause application, semis had to swap literally a major United States highways because of bad driving. They literally, traffic was stopped, all eastbound traffic was stopped because so many people were concerned. You remember that? Yes. And then it looks like the officers came into contact with, let's see.
Yes.
Deputy Thompson and I turned on our emergency lights and drove westward to stop traffic in eastbound lanes. They observed you, the black truck, and the slow lane attempting to get over the fast lane. While approaching the vehicle, was able to pass me getting into the grass median. So literally traffic was stopped. They were trying to block you in and you drove around everybody. Do you remember that?
So you have some prior criminal history, correct? Yes, sir. Looks like unlawful possession of syringe from 2021, right?
Yes, sir.
Battery is an 8 misdemeanor in what, 2020? Prior theft in 2020, is that right?
Yes.
Prior paraphernalia conviction in 2020, is that right? There's a prior 8 misdemeanor theft conviction in 2000. I got the question, you're just going to fully argument, Judge.
Argument from the state.
Oh, yeah, they're going to be checking everybody this week. Everybody.
I think two things. One, I think she probably a good candidate for JIP, but before she gets JIP, there's a price that she should have to pay for it. I mean, if you look at the probable cause affidavit, I mean, this wasn't just dangerous behavior, this was extremely dangerous. I mean, I can't think of a time when literally semis, she was literally, they blocked eastbound I-74 because of her driving behavior. And then when the cops got there, she drove around. I mean, if you look at the CAD or whatever, caller after caller, she's all over the roadway. I mean, we are lucky that this wasn't. And think about that. She had traffic stopped, which means there's traffic coming up and whatnot. I mean, it's a miracle that there wasn't crashes or things like that. She should have to do some jail time. I think JIP would be good for her, but before she does that, there should be a price she should have to pay for what she did. Then it was extremely expensive. And then if you look at what she was doing, heroin, amphetamine, fentanyl, marijuana, things like that. Basically, you know, what I mean, I understand she may have issues, but her issues jeopardized a lot of lives. That this isn't just your normal UI. You know, like in terms of when I say that, I put that in quotes. Turn signal, license plate light out, or whatever. I mean, I can't think of a time when actually semis before the police got there. That's how concerned they were. That's very, very, very unusual. I'm not saying in all cases that somebody, you know, who doesn't have a prior DUI deserves some sort of jail time, but I think we treat like cases like and different cases different. Her case factually is fundamentally different than some of the other ones that have whatever, and I think you should treat it different. I think she needs help, and I'm okay with that. I think she needs JIP and things like that. She earns it. She gets go probation, treatment, and stuff like that. But you should give her some jail time. Thank you. Judge,
She's accepted responsibility very, very quickly. Asked me to bring her over to court as soon as I could. Here we are. My hope is that her arrest saves her life, just like this semis likely saved somebody else's life. Drug treatment is entirely appropriate. She testified to 4. We're asking that we either be sentenced to some suspended sentence where we're ordered to go to this rehab facility, or go through the JIP process and go through a rehab facility. We're here to accept responsibility and move on. And she spent 12 years or 30 years using some very, very hard substances. It's miraculous that she's alive. She still has people out there who want to help her, and she's still quite young. So we are in your hands.
Thank you. One thing I will point out too, what caught my eye was this was the day after the race, you know, and so there's a lot of traffic going eastbound, you know, 300,000 people attend our race, and a lot of them are going back east. And that's what caught my eye, was the fact that I've maybe once or twice I've heard of semis trying to keep somebody from driving. So, you know, kudos to those semi-professional drivers who kept you off the road. I'm going to recommend the JIP program, but she needs to be evaluated for it. So I'm going to pause the sentencing and recommend the JIP. But what I'm leaning towards, just to give you, I'm leaning towards 730 days X on the 3 felonies, all concurrent, and then a year for the DUI, 180X. She's going to get 90 days in as part of the JIP, so that would take care of that.
She's got 34 actual days.
Right. And then I was going to give her probably 60 days on the driving while suspended, time served on that. So basically, you're going to get the JIP as long as that's recommended, and then that's about 90 actual days in to complete that. And then what I do is I modify your sentence and I would let you out. So I think JIP is appropriate, but that's not my call. I have to have you evaluated for that. So that's what I'm going to recommend. And let's reset this for July, let's say the 9th at 10 o'clock. So, okay, let's do that and then have you back.
I excel at semi-driving.
In a couple of weeks, and
I would imagine. Paul.
I think
With
so.
what they've done already, I would think.
I think so too, but we
gotta do it.
need to get the right blessing. So, all right. So Carrie, I hope this is an opportunity for you, that you are sincere about your desires and you have the ability to cope and figure it out. Okay. All right. Very good. Thank you. Brad, come on up. All right. This is Mr. Edwards, correct?
Correct.
All right, 73DO2 2102 F33. We're here on a petition to change placement from community corrections to incarceration. Is this the initial? Okay. All right. Do you waive the initial hearing on this?
We do, Your Honor.
All right. Have you had a chance to speak with Brandon?
Yeah,
earlier?
court recalls, we filed a motion to call one with a bunch of pleadings. Judge granted that based on what we filed.
I did grant it?
You did.
Okay, wow, that's unusual, but
It's pretty convincing.
I think you did, if I remember right, because he was doing deliveries, was that right?
And yeah, they said he was places he wasn't be, but he was literally like at docks dropping off his load.
Right.
And so Brandon just got on trial. He just said it needs some time to review it.
Okay, so I normally said it pretty quick, but you're right, given what you had, given me, because I thought, when I said motion recall, I'm like, I don't know. I'm like, oh, all right, okay, yeah, that's pretty good arguments. All right. August 6th, okay.
Must be fine, Judge.
And it sounds like maybe you guys can get it hammered out without me needing to intervene anyway.
But I got an email. You're on the Amplify
I am.
building. Okay.
I am. Yes, I am. So yeah, at Butler. So I understand yours is no more. So if you guys ever need a home away from home, I'm sure something could probably be worked out. Yeah, yeah. So yeah. All right. So Mr. Edwards, stay in close contact with your lawyer, okay? And then it's as you're figuring out, it's so important to be able to document where you are, what you're doing with those kinds of things. So make sure you continue to do that. Keep working. I'm happy you're working. That's what I want you to do. Okay. All right, you're good to go.
Thank you, Judge.
All right, thank you. Mr. Banks, Brad Banks. Yeah. Folks, I need to take a break. I've been on the bench solid. I promise we'll come back out and we'll get the morning finished up, but I got to hit the little judges.
We need the cameras and the microphones adjusted.
CM644 set for a change of plea hearing today.
Okay.
Yeah.
We actually had something worked out, and then I realized I should have defended with Chicago.
Okay.
This is going to be your first DUI through probation, but so I was going to do, we're going to do out of state thing, and I'll just say I should do it.
All right. This is basically going to be an open plea.
Yeah.
All right. Francisco, raise your right hand. You affirm under pains and penalties of perjury, testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I understand now. Okay. When that girl was up there with the semis that stopped her, the guy sitting on the left in the blue shirt with his hand raised right now, he was leaning in and talking real intently. And I thought he was talking to his lawyer. I didn't. She was standing right there, so I didn't see everything. And I thought, oh boy, because he was talking really intently. He's the interpreter. So I thought he was going to give us a long-winded, but no. Oh well.
See? All right, Mario, raise your right hand. Mario, do you affirm you will justly, truly, and impartially interpret to the court and any parties and witnesses any oath about to be administered, any questions that may be asked, and answers may be given this court if any cause may be considered during this court session?
Yes.
Court will take judicial notice of the talents of Mario Hayes, who speaks many languages, including both Spanish and English fluently, has been a court interpreter for over 20 years. All right, Francisco, tell me your full name. Domingo Santiago. Santiago? Okay, and Dominguez's father, Santiago's mother? Yeah?
Yeah.
Okay. All right. It's my understanding you're going to plead guilty today as charged to operating a vehicle while intoxicated and leaving the scene of a crash. Yes. Count one. Okay. Count two will be dismissed. Very good. You read Spanish. You understand by pleading guilty today, you're giving up all the rights listed in the back of your appearance form. See?
Yeah.
Did you go over these rights with your attorney? Jennifer speaks Spanish, and you understand her Spanish. All right. You understand I could sentence you anywhere from 0 to a year in jail, and from 0 to a $5,000 fine. See?
Yeah.
You understand this matter will also count as a major offense and will count towards you being a habitual traffic violator. Has anybody forced, threatened, or coerced you to plead guilty? Has anybody promised you anything? You are, your date of birth is July 1st of 1990. And you were born in Mexico.
Yes.
Are you a United States citizen?
Yes.
You understand pleading to this risks you being deported?
Yes.
And have you and your attorney discussed your possible immigration consequences?
Yes.
How do you plead then to operating a vehicle while intoxicated as a Class A misdemeanor? Guilty or not guilty? On October 11th of 20, you said culpable? See? Guilty? All right.
Yes.
All right. On October 11th of 2025, were you driving a motor vehicle in the streets of Shelby County, Indiana?
Yes.
You were impaired, correct?
Yes.
You were impaired by alcohol or drugs or both?
Alcohol.
What were you drinking that day?
Beer.
How much?
6 or so.
Where were you drinking them?
Afternoon.
Was this a blood test result, Mr. Zick?
What 182?
Apparently you tested 0.182 per 100 milliliters of blood. Is that correct?
Yes.
All right. You were a danger to yourself and other folks out there on the road. Is that correct?
Yes.
All right. Mr. Zick, I see where he drove through somebody's yard. Did you ever get any information from the victim?
We did, Victor was asking for $1,000, but the issue I had with it is that I wanted some sort of itemization or whatever, because he said he had certain things, and we had asked for that, and never got back, so.
We asked for
Yeah,
$1,200.
so what he did is, he sent both of us. Yeah. Said estimated cost $1,200, like $400 for seeding, $300 for equipment, $300 for labor, $300 for soil. But you know what I mean? So I get that, but I also try to get some proof, so I have that. So he did ask me that, so but I don't, he never responded.
It's kind of pricey for seed.
Yeah,
Yeah. All right.
that's why I asked for proof of that. And to be fair, we did, our NDC did ask a number of times to provide that. That was never provided. So
Okay.
I did make her aware of that as well, because that's why I was kind of torn. I wanted to go to Victor says, but in this case, I wanted to give me an itemization type of thing, whatever, and I never got that. So.
Okay. All right, and a recommendation from the state, or fine, let's back up. Upon your plea guilty, I find you guilty. I find your plea to be knowing, intelligent, and voluntary, and there is a factual basis. Enter judgment of conviction for operating a vehicle intoxicated as a Class A misdemeanor. Recommendation from the state.
A typical person, like, judge, pass probation every 8 days, the AID class, $200 alcohol, everybody.
All factors into consideration, who lives in Chicago and was here for work purposes, was not intending on staying in the area, and he has not been driving since the event. He has someone here with us today to drive him around. He does not have his license. So we just ask that the court take all of that into consideration.
Actually, I'm going to sell my neighbor's yard too. Might as well.
Okay. Is there anything you wish to tell me, Francisco? You have the right of allocution. You can tell me anything you want prior to being sentenced.
Education a day, I have those previous charges, that's all.
Okay. All right, I'm going to find you guilty of operating a vehicle intoxicated. I'm going to sentence you to 90 days. It's all suspended. How many days was he in custody?
It's 1 day, Your Honor.
All right. Suspend all but 2 days, give you credit for 1 + 1 day served. The suspension is conditioned upon you paying a total of $26.89, which consists of an $1,800 fine, $500 in restitution to the victim. Do you have the victim's information, Mr. Zick? $189 in court costs, and a $200 DAPIC fee, or countermeasure fee. I'm sorry, countermeasure fee.
Victim is the order.
All right, and we'll have to get that information eventually, or how do we normally get that to the clerk? He just put in the system. Yeah. Okay. All right.
Okay.
All right. Do you have $2,689 in cash with you today? I'll give you some time. So you, if you need, yeah. All right, I'm gonna set a compliance date. If it's not paid by that date, then I can seek to have the balance of that suspended time executed. Do you understand that? So I want you back in my court on July 16th at 10 o'clock. If it's paid by then, and your attorney tells you it's okay, you don't need to be back. Otherwise, I need to see you July 16th at 10 a.m. Yeah. The bond that you posted of $600, $550 will apply, so you're going to owe $21.39. Thank you, Ed. Your license is suspended for 180 days because there was an accident, and that will be consecutive to your breath test refusal. Probably a moot point anyway.
You're asking.
Give me the victim's name again, Ed.
Order.
DEA.
Yeah, order.
Dean.
I gave her the address
Okay.
as well.
Okay, perfect.
I didn't know.
All right, Francisco, this was an open plea. If you do not like my sentence, you may appeal it. Do so by filing notice of appeal with the clerk of the appellate court within 30 days of today's date. If you could not afford an attorney for the appeal, I could appoint one for you. Okay? Do you have any questions?
No.
All right, you're free to go. Thank you. Huh? Yeah, have him wait for sentencing order. Who do you have?
Brian Barnes.
I got an interpreter I want to get rid of. I'm paying good money for an interpreter. Who's here for my Mandarin interpreter? Yeah, come on up. Up here. No, just up here. It's good. At the bench. Who's your client?
Mr. Zhang. Zhang.
Hello, Beck Love.
Zan. You have his appearance form. Perfect. Thank you. See at my 11 o'clock or? Yeah.
Doesn't that look like Mr. Chargaloff? The new
All right.
judge.
73 DO2 2606 CM367. I have Mr. Zhang here, represented by Jeremy Johnson. And I have Edward Wong, my interpreter, correct?
Yes.
And you are certified by the state of Indiana for Mandarin, is that correct?
Correct.
And does Mr. Zing speak Mandarin?
Yes.
Okay, very good. All right, raise your right hand, Edward. Do you affirm you will justly, truly, and impartially interpret to the court any oath about to be administered, any questions may be asked, and answers may be given, this court for a cause may be considered?
Yes.
Perfect, thank you. All right, Mr. Zhang, raise your right hand. Do you affirm under pains and penalties of perjury, testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, tell me your name.
Xing Zheng.
Sing Sung?
Zheng.
Zheng.
Yes.
All right, all right. What is your date of birth?
October 13, 1971.
Where were you born?
China.
Are you a United States citizen?
No.
As a Chinese citizen, you have the right to have your consulate notified you've been charged with a crime. It's not required, but I can notify them if you wish. Do you want me to notify them?
What is that?
Under an international treaty, individuals charged with crimes have a right to notify their home consulate that they have been charged with a crime. I'm advising, okay, no, okay. Because you're not a United States citizen, this matter could also result with you being deported. So you need to make sure you discuss possible deportation consequences with your attorney. Do you understand that?
Yes.
Okay. Do you want to waive the remainder of the initial hearing then, counsel?
Yes.
Okay. All right. You understand you are charged with operating a vehicle while intoxicated. That is a Class A misdemeanor, punishable from 0 to a year in jail and 0 to a $5,000 fine. It also counts towards you being a habitual traffic violator. I see you have a prior conviction. So this would be a second offense if you are convicted within 10 years. One more major offense, your license is suspended for 10 years. Do you understand that?
Yes.
Okay. All right. I will set this matter for a pretrial conference. You just use any day. It'll be in the magistrate's court on July 28th at 1:15. That is in the basement of the courthouse. That's underneath your feet. Do you need the interpreter to speak with your client at all about anything today, or?
Maybe just for a minute out there, Judge, and I got his contact info.
Okay.
He's gonna help me going forward.
Okay, all right, all right. Well, that part will be on your dime.
Sir.
All right, so, I found this probable cause. I'm suspending your license. No more driving until your attorney tells you differently. You understand that? Did you drive here today?
No, my wife drove me.
All right, no more driving. Okay, all right. That's it. Very good. Thank you. Pretty good. Yeah, you're welcome. Thank you, sir. Huh? No, that's just no, we still have to have ours.
Okay.
He's using him for his personal correspondence back and forth. And yeah. Yeah, no. So Jenny, they need to know they have to have an interpreter here. And since he's certified, let's use him because we can pay him with our state dollars.
Okay.
Yeah. Well, yeah, talk to him directly. All right, ready? Yeah, come on. Thank you. Sorry, I just
Understood. This is Brian Barnes, Your Honor.
got it. 73 DO2 2508 F6 220. I don't show your appearance. State your name for the record, please.
Brian Barnes.
No, your attorney.
Michael OJ.
Yeah.
Hi,
All right.
Bryden.
Brian Barnes.
Yeah. All right. What are we doing today, Mike?
Your Honor, Mr. Barnes pled guilty some months ago, and as part of his term and condition of this plea, there was an agreement that he could petition for early termination of probation after 6 months, provided essentially good behavior, doing all that was asked of him. He has done that. We have filed our petition. It is my understanding that probation has no objection to termination of probation.
He's done well, Michael. Good.
And, they said that, this is a violation.
So both him and Amy are leaving probation today. All right. Probation officers retiring today. Quitting, I like to say, but yeah. All right. Well, good. Well, congratulations. All right. And they'll show probation terminated effective today.
Thank you, Your Honor.
All right. Thanks, Mike.
Thank you.
Nice seeing you. All
Take
right.
care.
Yep. See you. All right. Good luck. Yep. All right. Yeah, sure. Yeah. You said Asher? Was this set at 10 o'clock?
Yeah.
Okay. 73 DO2 2509 F6 359 set today on an initial hearing on petition to revoke probation for Ricky Asher. Grace Dillon appears on Ricky's behalf. You waived the initial hearing then?
Yes, Your Honor.
What are we doing today?
Just get a date, Your Honor. I saw Brandon pop his head in. I tried to talk to him this morning, but I think he's up in circuit. So I'm
Okay.
gonna try to catch him while I'm still in the building and see if we can get this resolved.
Okay. All right, you understand the allegations as you consume methamphetamine, marijuana, and alcohol. You understand that, Mr. Asher? Yes. All right, here's copies of the petition. Any instructions from probation regarding Mr. Asher? No? Okay. All right, I will set this matter then for a fact-finding hearing July 16th at 10 a.m. Obviously, conduct between now and then, Ricky, can influence what I do. You understand that and how this case gets resolved. You are on probation. I expect your behavior to be consistent with those terms and conditions, okay?
Yes, sir.
All right, you are free to go.
Thank you, Judge.
Thank you. Oh, Ed, or Adam, I guess it'd be Adam. We were told that a Jameson friend passed away And my staff looked up and there was an obituary form. Somebody called and said, hey, it's an infraction of speeding. So stay moved to dismiss. Okay. Ready? Yep. Hanover. You still basking in your victory from yesterday?
It says you and Park.
Yes. No, that was good. All right.
Surprised how many people look at those. But that lot of people.
Really? Yeah. Well, good. Well, it's hot off the press, right? So.
You were the quickest, though, so like the same day.
Yeah.
Like within a couple hours.
Yeah. Well, that's my usual light lunch reading is trying to keep up with the opinions.
Good for you. My husband said
You're just driving on the roads, Bryden. Just driving on the roads with all the damn potholes.
Yeah. 73 DO2 2601 CM32. What are we doing Zane today?
Your Honor, we're here on a petition to revoke probation. He's going
Hallam, is that in York?
to admit to violating probation. He failed to keep up with his appointments and communication with probation. Our agreement is to execute 30 days of his previously suspended sentence. It'll be consecutive. He does have new charges. And we're going to give him a credit. He's already got, I guess, the credit for that, so he's 15, but he's not leaving the jail because he's has some trouble.
Are those charges in my court?
They are. Good. It's pointed to represent. I don't think there's spoken more in that. I have it that there's a pretrial processing license.
All right.
You need the paper.
Yeah, let's do it. Yeah, because we'll need to make it consecutive to that.
So it'd be 2604 CM 272.
All right. All right, Zane, is that what you wish to do? You heard Amanda recite everything. Is that correct?
Yes, Your Honor.
All right. Raise your right hand then. Do you affirm under pain and penalties of perjury testimony you're about to give is
You're maybe 20 minutes away from me. Maybe a little longer.
the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Okay. Tell me put your hand down. Tell me your name.
Zane Edward Vanover.
All right, Zane, you're on probation with me. Is that right?
Yes, sir.
You understand you're admitting that you violated probation today. Is that correct?
Yes.
You're giving up your right to a hearing. Do you understand that?
Yes.
State doesn't have to prove by preponderance of the evidence that you violated probation. You don't confront or cross-examine anybody. You don't have the right to.
Braden, they're going to have like these outdoor concerts in Spring at Sperry Park. I think Wednesdays and Sundays or something like that. They're really fun. You should look that up.
Appealing decision. You don't have the right to subpoena witnesses and present evidence your own defense. If you were